All right, let's explore this further now. We do have, again, employment law consultant, employee relations advisor and accredited commercial mediator, Galeboe Modisapodi, who is joining us now. Good evening to you, and thank you so much for joining us once again. Of course, this matter playing out in court, much of the argument centering around subsection 15A of the Employment Amendment Equity Act. But the DA, right, arguing that the previous law struck what it calls an appropriate balance between fostering transformation and also protecting the rights of undesignated groups. Did you agree with that argument?
Well, the argument is difficult to agree with because, as the other side has submitted, Section 15A doesn't change the scheme prior to the amendment. So I think they went to great lengths to articulate how exactly Section 15, I think it's subsection 2 and subsection 4, remain valid, and a number of other sections in the Employment Equity Act. So Section 15 doesn't change that at all. If anything, the argument that seems to stand a bit of ground at the moment is the argument that says that all the change that Section 15A does is to put an additional layer at a sectoral level. It doesn't take away the rights of employers to set their own targets given the specific context. So there were two issues which I think were quite key in the argument submitted today. The first one was Section 15A doesn't change the framework as it was before the amendment. The second one is that employers can still make a case around why it is not possible to comply with legislation. And if that is the case, then within the confines of the Employment Equity Act, the minister then can exercise a decision as to whether or not to grant contracts or not. So the argument by the DA seems to be rather difficult in terms of how it also fits into the scheme that says Section 15 itself is entirely unconstitutional.
And I wanted to go to, your next point, that the minister, of course, saying that the law does make provision for employers to justify their failure to meet the targets on reasonable grounds, she says. But is it clear what constitutes these reasonable grounds?
Well, in my understanding and my reading of the Act and also listening to the arguments, the reasonable grounds are not a new phenomenon at all. They existed prior to the 2022 amendments. So what was reasonable grounds then, it seems to me still applies now as it did prior to the amendments. I struggle to find a basis during the hearing where the minister now has additional powers or discretions to then say, I'm not going to exercise the discretion to say you have reasonable grounds for not complying. So the DA's case seems to be very difficult in the sense that, as I submitted yesterday, it seems to be stretching the definitions beyond what is provided in the legislation.
And also another, argument I want to pick your brain about is that the party claiming, that's the DA, that implementing the demographic targets disproportionately prejudices coloured and Indian communities in certain provinces, particularly the Western Cape and KwaZulu-Natal. Does it?
Well, Section 9, subsection 2 of the Constitution prohibits that. I think that's the first one. And I think the counsel for the first respondent also made argument that whatever changes that or amendments that have resulted from the 2022 amendments are still within the confines of the law. And Employment Equity Act itself provides, I think it's in section 9, it provides the framework within which employment affirmative action is permitted. And in its provision, it says very clearly, affirmative action is not going to result in not even the non-designated being disadvantaged. So you cannot have a situation where an employer is forcing a non-designated employee out of work to create space for a designated employee, because that will be against the Constitution. And both the Constitution and the Employment Equity Act make those 2 points very clear and very strongly.
So when you then look at, of course, what you've just said in the arguments, because clearly, as you and I were even discussing yesterday, and what the president was talking about as far as the ILO is concerned as well, and what some of the concerns there around some of our labor laws in the country, there is a clear need in South Africa to redress. There is a clear need, of course, to strike a balance here as to how this gets done, and the issue of transformation that we continue to hear about. So when you're looking at these arguments that have been laid out in court, how do you see this one going?
Well, I think the judge presiding is going to have a very tough day, or tough few months before submitting their report or their judgment, because there's a number of highly technical issues that were raised by all the parties. And I think the key question that has to be answered is whether the amendments, not only Section 15A, but the others as well, whether they give unfettered power to the minister, firstly. Secondly, whether they go against the tenor of Section 9, subsection 2 of the Constitution, and whether there are no guardrails that the amendments give to the minister. And if there are guardrails, and the guardrails are very clear, the likelihood is that the judge will rule in favor of the respondents. But if there's any conclusion that the judge reaches that there are some aspects of the amendments that don't have very clear guardrails, then the likelihood is that the judge might give an order that says this is where the problem lies in terms of unfettered discretions, and give a bit of time to Parliament, normally a year or two, for Parliament to effect revisions to ensure compliance with the Constitution and constitutional legislation.
As you say, it's going to be an interesting time ahead just to see how this one, plays out, especially, as you say, on the issues of the minister's powers. What does the court say then? And also, the important guardrails that you're raising there. So let's see then how this one, plays out in the courts. Appreciate your time this evening. That was employment law consultant, employee relations advisor, and accredited commercial mediator, Galeboe Modisapodi.